Good morning, everyone, and thank you very much for joining us for Lewis and Roca's presentation today on remote working and data protection, a pandemic year in review. As everyone on this presentation is well aware, in March of last year, most of our working and professional lives changed dramatically with COVID-19 and the sudden shift from a workforce largely office-based to a professional workforce that was largely based at home. We saw our IT departments pull together and quickly put in place structures for employees to be able to effectively and productively work from home. And now, a year later, we have lessons learned and additional cybersecurity threats and threat intelligence that we would like to share with you today. My name is Hilary Wells. I am the chair of the Data Protection and Cybersecurity Group at Lewis Roca. I've been with the firm for 18 years, and prior to that, I was working in the insurance industry on the underwriting, claims, and even as a producer. And so my background is largely with insurance and progressed into banking and other financial services. I came to this space because it was really the insurance carriers that identified the cybersecurity risk and the need in the market to work through how do we actuarially account for this risk? How do we appropriately price for it? And is there a product out there or products out there that can be offered to businesses who are working in a space where, unfortunately, third-party actors are engaging in criminal conduct, and sometimes it's just the negligence of employees that can lead to significant financial losses. Here with me today are two members of our cybersecurity and data protection team, John Gray and Ed Barkel. John Gray is a certified information privacy professional. He represents clients in a variety of privacy and security matters, including litigation across California and Arizona. Before joining us, John served as the data protection team leader at the Arizona Attorney General's office and as a co-chair of the Technology Futures subgroup for the Arizona Cybersecurity team. We are very pleased to have John and his regulatory and employment expertise join us in our practice. Ed Barkel is a partner at Lewis & Roca, and he's the lead partner in the firm's security litigation and broker-dealer litigation practice group. Ed is a partner in the firm's litigation practice, and he's a member of the firm's data security team. He brings to us a very long background and resume in advising those in the financial services sector who face various privacy regulations and requirements from a supervisory standpoint. And we welcome Ed to the presentation today. Remote working, as I said, we've all experienced a dramatic change in the past year. And today, John, Ed, and I would like to give you some lessons learned and some perhaps advice about paths forward. I'll turn it over to you, John.
Okay, very good. So thank you for that introduction, Hilary. And I just wanted to cover some of the things that we've seen, sort of generally speaking, from a remote working perspective over the last year, including sort of how it's going from a practical perspective. So PwC recently published a survey on January 12th of this year, indicating that 83% of employers and 71% of employees thought that the shift to remote work in 2020 had been either successful or very successful. So it seems that the overall shift to remote work was pretty effective for a lot of companies and for employees out there. As a result of that shift, 70% of executives say that they are planning to increase investment in IT infrastructure to secure virtual connectivity in 2021. And that's an important step, and we're going to talk a little bit about that today during the webinar. But I think given executives' increased in IT infrastructure here, I think we're going to see a lot more movement towards remote working over the next year, 2 years, 3 years, and pretty far into the future. And again, as a result of that, 52% of employers indicated that employees were actually more productive or much more productive working remotely, but 98% of them expect to have at least 50% of office workers back in the office by January 2022. So again, I think at least half of employers out there are viewing the shift to remote work as having been pretty successful from a practical perspective. However, the survey did indicate some differences between employers and employees, as you might expect. Employers, for example, indicate that the primary purpose of having an office is increasing employee productivity, which is a little bit disconnected from the prior answer that employees were more productive or much more productive working remotely. But in any event, employees thought that the primary purpose of an office was collaborating or accessing equipment or documents securely. And personally, I tend to fall in this latter camp in terms of what I would hope employers and employees are getting out of the remote working environment is, they may be missing some collaboration and they may be missing the equipment or documents being accessible securely, but the productivity seems to be there. So getting people back into the office, I think certainly is going to increase collaboration and is going to allow people to more easily access equipment and documents securely. And so we have a similar survey from Mercer, another recent survey published this year. Mercer is an HR consulting firm, so they deal with a lot of these types of issues. And according to this survey, 94% of employers thought that company productivity was at least the same, 67%, or even higher, 27%, than before the pandemic. So this is consistent with the PwC survey. Employers basically believing that productivity was about the same or better than it was before the shift to remote work. And 83% of employers plan to continue with increased employee flexibility post-COVID. This doesn't necessarily mean that it's going to be 100% remote work, probably a lot of mixed or hybrid environments. But 1 in 3 companies did say that they expected to have half or more of their workforce remote, even into the future beyond COVID. So I think these issues are not only timely, we've not only seen a lot of it over the past 12 months, but we're going to see a lot of these types of issues continue to arise in the future as companies figure this out and really shift completely to a remote working environment or at least a hybrid environment. But of course, there are some challenges of remote working, and Ed's going to talk about some of those.
One challenge is remembering to unmute your Zoom. I think one of the major issues that we all have is, and all of our organizations have, is that the immediate shift to work from home created all kinds of problems, and it became the number one priority for most management teams during at least the early stages of the pandemic. Some of the issues that companies faced included employees shifting to home using unsecured personal equipment. Some of that equipment had viruses on it from, just poor cyber hygiene to their kids downloading stuff on the same computers that they're using for work. Many employees had open Wi-Fi, never updated their password for the Wi-Fi from admin and password 123, things like that. And then also, companies had to worry about, especially in the financial services sector, that employees were using the same home computer to access confidential client information that their kids were using for school or fun in the evening. As a result, the FBI saw a 300% increase in complaints related to cyber phishing, different kinds of attacks and things like that. And in fact, they noted that there's been a 600% increase in spear phishing attacks. And for those that don't know, a spear phishing attack is a targeted email to an employee where the bad guys are trying to use social engineering to try to get the employee to open the email, respond to the email, or download an attachment or open an attachment that can download malware. And some of the social engineering approaches that they use include emails from a senior official's email address. The president needs gift cards to hand out to clients, or needs somebody to go buy Amazon gift cards and send all the codes to his assistant so that she can send them out to clients. Things like that. And they also rely on fear, urgency, and I'll go through a little bit of this later as well. and use those methods to attack. And according to the Atri Group, 94% of attacks on financial institutions occur through phishing. So training is crucial to help employees identify what a phishing email looks like. And I'll show you an example in a minute of just some of the flags that you might see. One of the other issues that has been identified is that early on, many employers tried to use fear, penalties, terminations, things like that to get employees to take seriously the risks involved with the phishing attacks. And what they found is that creativity and trust are a far better system than fear. Employees ignore at some point the warnings. They hide mistakes because they're afraid of retribution. And instead, what they found is that creating buddy teams, for example, if I have a question about an email, I contact somebody else in my department that may or may not have gotten it, and we talk about it. Or designating a key individual in the group who's in charge of these cyber questions, and then providing extra training to that individual. Another issue that many companies faced is that employees were downloading confidential information, protected information onto alternative devices or their own home networks, for example. So some use thumb drives, things like that. And it's not as big as it used to be, but there are individuals and hackers that use what they call drop flash drives, where the flash drive is free, but it has loaded on it malware. The regulators have also issued warnings and guidance. CISA, the FTC, HSS, EEOC, and FINRA, for example, and the Fed have all issued guidelines, and those are pretty readily available online. So this is an example of a phishing email that I received, and there's a bunch of red flags in this, and I'll run through them pretty quickly. For number one, the Cox, the first two letters are in bold, but the third letter is not. The email address that this came from, subsupport@carolinarr.com. Why would Cox send an email to me indicating that there's something very important with my account, but not send it from their own email address? As you can see in the upper left corner, there's the urgency, very important alert, a warning. At the end of the email address, you can also see that there's two semicolons, which means that somebody or some other addressee was removed from that email. And then as you move through 4 and 5, 6, you'll see that there's typos. Cox ID is in different capitalizations. 7, the next paragraph starts with a small letter I instead of a capital I. More typos at 8. There's a space between identity and the comma, but not between the comma and weave. Again, number 9, the Cox ID is different. And one of the most important is the verify your identity is going to ask for key information related to my account. And if you had this email live and you rolled your cursor over quick reply, reply all, forward, delete, and the verify identity, they all go to the same IP address, a link, which is not Cox. It's just a string of information. John, next slide.
All right. So cybersecurity and data protection. What have we seen and what lessons can be learned from the attacks and more public events that we've seen advertised involving cybercrime and the impact of cybercrime on clients who are, like most businesses, very reliant on software systems and software vendors to provide various services to them? And so in talking about cybersecurity and data protection, I find I'm often going back to my background in insurance. Insurance is a risk mitigation or risk transfer tool, and it can be very effective, but it's important to understand what it is and what it's not, and what coverage it does afford and what coverages are excluded. And so some of the questions we saw arise over the past year is, what happens when there is a compromise of a third-party system? We're going to talk about some of the three of the more widely advertised data breaches in just a moment. But what we learned from third-party systems and third-party system breaches is that even clients with very good cyber hygiene, who have undergone data inventories, who have done data assessments, who have really gone through and thoughtfully addressed what information they have, why they have it, and how long to keep it for, even those clients found themselves at risk and vulnerable because they were relying on software vendors to provide various services for them. For example, HR benefits and HR benefit processing. There are numbers of software services out there that are very efficient in providing those services to clients and to client employees. However, in order for those software systems to work effectively, of course, private employee information needs to be stored on the system. Well, in the event of a breach, that is actually a third-party system that's been breached. So it's not the client system or the client's employee who's been impacted by the business email compromise or the spear phishing that Ed just spoke to, but it's an entirely independent system that the client has no ability to audit, no ability to forensically study, and really doesn't have the access to information concerning what were the security protocols, what information was impacted, and how. And so we find clients at risk of third-party vendor breaches and trying to work through what you do when you can't know what the actual system compromise was. And so this was one place where we saw insurance in several instances was effectively layered into the client's risk portfolio in a way that even though the client might be the party responsible for providing notification to the employees or to affected customers, that the insurance was able to at least provide some financial services around obtaining lawyers to assess what the legal obligations are, when necessary, paying for notifications, at least up to certain sublimits and the like. And so that was one place where we saw a real exposure for our clients, which is, again, the benefits of technology being some facets of the business, some aspects of the business process can be onboarded onto effective vendor software systems. The corresponding risk is that the client doesn't control that platform and doesn't necessarily have the ability to perform a specific assessment in the event that platform is breached. The same is true with employee home networks. What we saw here was, employee networks that were unsecured, as Ed was explaining, were being used for various business activities, frankly, out of necessity. And as a result, in the event of a compromise, there can be an issue with respect to how much access the client employer has to the employee system, and whether or not, if there is malware deployed, whether the insurance coverage for the business might afford coverage for the employee's damaged systems. And I'll tell you that the answer to that question is very policy specific. And you need to be very careful about the extent of employee use of their own equipment and systems, because the business policies affording property coverage that may extend to damage caused by a cybercrime may very well not extend to the personal property of an employee who's using it for business. Like I said, I've seen it go both ways, but it's something to be mindful of. And so when we talk about vendor risk and software tool compromise and how do you manage that? I think it's best to probably put into context how these breaches have played themselves out over the past year in particular. SolarWinds was a breach that received and continues to receive a significant amount of attention. As you may know, the Biden administration recently imposed sanctions against certain Russian actors who are believed to be responsible for the SolarWinds attack. SolarWinds, like the compromises I was just describing, involved a software system. The system was named Arisen, and up to 33,000 clients of SolarWinds were impacted by the compromise. These are government agencies. These are Fortune 500 businesses. These are small and mid-sized businesses. And the way this compromise worked was once the Orion system was compromised by the cybercriminal, the code that was launched created a backdoor into the customer's information technology systems. The hackers then used that information to help them spy on the client companies and organizations. And so it's widely believed that the true impact of the SolarWinds compromise is not yet completely understood or known, because again, what the hackers did very effectively was identify a software system utilized by a number of different organizations of interest, and were able to successfully compromise that system in order to effectively hack the client government entities, small businesses, large businesses, and the like. And so one of the things we saw come out of SolarWinds was a real discussion and talking point around software updates. I think at least those in the who are expert in security that I speak to tell me that, of course, you promptly install any security patches that are provided by a software vendor. So if a software vendor has identified a security vulnerability and a patch is deployed to customer client, reporting that we have a vulnerability that we think we've addressed, that type of patch or update should be immediately installed. But the other question comes around just regular updates. Does it make sense to just as a matter of rote habit, provide and install software updates every time they're provided by the vendor? And I found that a number of groups are rethinking their philosophy on this. I had one security expert explain to me that he approaches software updates with the philosophy around, is the current version meeting my organization's need? Is there a need that this new update can satisfy that the existing version does not? And if the answer to that question is no, or perhaps no, then there might not be an urgency in downloading that particular update, because with every update comes the opportunity, unfortunately, for compromise and for problems. And so I think we've really seen security experts and those in charge of security teams rethink the update and the response to updates. With Blackbaud, we saw what we like to refer to as ransomware version 2. Ransomware originated, and its core form is, like Ed was explaining, deploying some sort of malicious code through an attachment, through a link, and the like, and locking down the client system so that the client is left with the Hobbs-in choice, really, of either paying ransom with the promise that keys will be provided that will provide access to the system. So you're relying on a criminal's representation that in exchange for extortion, ransom, that they will give good keys and that the information can be accessed. Well, in response to that, we saw a lot of organizations go to more robust backup systems. We saw organizations really evaluate the connectivity of the backup system to their primary servers and their primary storage systems, because what ransomware version 1 taught a lot of groups, unfortunately, is that unless the backup is completely disconnected from the primary system, the backup system can also be compromised and locked down, which doesn't leave it as a way or a vehicle to avoid paying ransom. And so, of course, cyber criminals, being who they are, and the motivation of profit and money being what it is, came up with a second way to try to extract ransom. And that is to launch the malware into the system, exfiltrate a certain amount of the client information, sensitive information that the client would be concerned about, and then launch the malware for the ransom. And in this version, what we saw with Blackbaud in particular is Blackbaud actually detected the ransomware before it could be launched. And so in that circumstance, they were able to lock out the cyber criminal before Blackbaud itself was locked out of its system. However, Blackbaud still paid ransom. And the reason it paid ransom is because of the earlier exfiltration of sensitive information. So the cyber criminal built in a backup plan for itself. So even though it couldn't extract the ransom because a system was locked up, they were able to extract ransom on a threat of publishing to the dark web and otherwise the sensitive information that had been exfiltrated about clients prior to the attempted launch of the ransomware. And so finally, and I'll run through Shopify quickly, this incident demonstrated the real risk that can come with employee negligence and bad actors. Shopify was a bad actor, and again, vendor risk. And here what we saw is that A 18-year-old in California actually was indicted just at the end of February for this crime and for this cyber attack. What he did is allegedly contracted with an employee of a vendor located in the Philippines. That vendor was hired by Shopify to perform all of its customer service work. The employee at the vendor was actually in a customer service center and he was monitored. Notwithstanding that, he was cognizant of what kind of logging was done, where his managers were located, and he did agree with the 18-year-old in California to extract client information, merchant information from Shopify, upload it into Google Drive in exchange for two things. The employee in the Philippines wanted a payment, of course, and he also wanted the 18-year-old to arrange for someone to leave positive reviews about his customer service skills. And so it was an interesting hybrid where it did play on to a need of this customer service representative, which was in part financial and also in securing and bettering himself in the workplace. The payments, interestingly, were only between $20 and $300 per merchant transaction. So for the 18-year-old who was able to work with someone in Portugal to arrange for the positive reviews that were the second component of compensation, the actual financial out-of-pocket spend for him to obtain this information was relatively small. Like I said, to be clear, he was caught, he was identified, at least, and he's been now charged but not convicted of wire fraud. And so here again, we see a threat that was created by a business need to externalize customer service, but then exposed the business Shopify to the risk that there would be employees and contractors in that third-party network that could be at risk for being exploited by a cyber criminal. So I'll turn it back over.
Okay, thank you, Hilary. So data privacy now I'm going to talk a little bit about in the context of remote employees, and certainly this overlaps to a large extent about some of the material that Hilary just described. Certainly you can have rogue employees on the one hand attempting to steal your data, and so you want to prevent that. But at the same time, you may have many obligations with regard to your good employees, those employees who are doing the right thing, and protecting their data or protecting the data of your consumers or your constituents, depending on what type of organization you are. So just as a little bit of background, many of you probably know this, particularly if you're in regulated industries, but I did want to give a bit of background on some of the relevant laws in this space and how they've changed over the past 12 months, because we have seen some changes in this space with regard to data privacy and what organizations have to do to meet those obligations that they may have. So the U.S. federal privacy laws, Ed mentioned some of the regulatory updates, some of the agencies that have issued new regulations. The federal privacy laws themselves, for the most part, have not changed. And again, as most of you probably know, these laws are typically organized around industries. So you have HIPAA, for example, for the healthcare industry and certain healthcare data. You have GLBA for financial institutions and certain financial information. And so a lot of these laws, although the laws themselves have not changed, the agencies that are responsible for enforcing these laws have issued significant guidance. And unfortunately, I can't really walk through all of them here today. I don't think we have the time to do that. But just by way of example, the HHS did relax certain HIPAA regulations, both under the privacy rule and the security rule, for certain organizations and doctors who were making a good faith attempt to deliver telehealth services during the pandemic. So in other words, doctors and other healthcare providers were able to use and are still able to use Zoom or Microsoft Teams or other video conferencing software of that sort, even if they're not otherwise complying with HIPAA or a business associate rule. In other words, these organizations don't necessarily have to sign up for the more expensive version of Zoom or Microsoft Teams that are HIPAA compliant, if they are making good faith efforts to deliver telehealth services through those platforms. Certainly, if you have the means and it's reasonable for your particular organization to take additional steps to make sure that you are complying with HIPAA, both the privacy rule and the security rule, and you're in this space, that is still important, but the HHS is not going to penalize healthcare providers for delivering telehealth services during this public health crisis through some of these remote working technologies. So that's one area where we have seen government organizations, agencies attempting to assist companies or not come down hard on them for moving to this remote working environment when they have to, particularly those organizations that have an important role to play in public health. And at the same time, we've seen certainly state laws have been updated. So although the federal laws have not changed, some of the state laws have. The biggest among those is certainly California's CPRA, which is the California Privacy Rights Act. That act was passed this last year and adds on to the existing CCPA requirements. Similarly, Virginia just passed the CDPA, or the Virginia Consumer Data Protection Act, which is largely similar to the CPRA in many ways, somewhat similar to the GDPR. But thankfully, both of these laws, for the most part, particularly with regard to employees and remote work, they don't really take effect until 2023. Some of the provisions of CPRA already are in effect. Some of the provisions of the earlier CCPA in California already are in effect, but most of the specific requirements for employees and remote working environments are not yet in effect. So companies do have a little bit of time, but this is an area where we've seen substantial movement over the past 12 months. And I think we certainly anticipate significant movement going forward, both at the state level, other states passing state-specific data privacy laws, and then probably at some point the federal government stepping in and passing some sort of more comprehensive privacy legislation. I don't think they're there yet, but they may get there sooner rather than later. And similarly, we've also seen significant updates at the international level. Probably primary among those changes is that the EU-US Privacy Shield was invalidated in the last year. That was in July 2020. Some of you may be familiar with this decision. It's known as the Schrems II decision. But that basically means that if your organization was relying on the Privacy Shield to transfer EU data subject information from the EU to the United States, you can no longer rely on that Privacy Shield. That doesn't necessarily mean that you should leave the Privacy Shield. I think there may still be benefits to participating in the Privacy Shield. It still exists as a thing, but it is no longer a sufficient basis on which to transfer EU data to the United States, at least according to the EU. So you now need to be relying on some other method. Primary among those methods are standard contractual clauses. But even those are not entirely sure to be valid. So that's still an open question, and it's not really clear at the moment whether you can transfer EU data to the United States in a compliant way. And that's being tested right now, and it will continue to be tested in the EU. So that's sort of yet to come, and I'll talk a little bit about some of the obligations in that regard that arise from employees working remotely. And at the international level, we're also seeing new laws being passed. Some of these may not be particularly relevant at the moment, but as more and more countries start to pass these types of laws, companies are really going to have to be focused on where they operate, where their data is coming from, where their data is going, and how that data is being treated. So, for example, Brazil, its LGPD came into effect within the last year, or for the most part came into effect within the last year. And Japan amended its Act for the Protection of Personal Information, or APPI, just recently. And so, again, we're seeing more and more countries passing these data privacy laws or updates to their existing data privacy laws. And so organizations really need to be on top of this type of thing. And at the moment, most of those obligations relate to this last bullet point here in terms of notice, consent, opt-out, and disclosure obligations. And this arises as an issue, particularly with remote employees, because a lot of companies that didn't have remote employees before hadn't been disclosing any transfers between remote employees because those didn't exist. But now with organizations having remote employees, perhaps in different states or perhaps in different countries for that matter, have you as an organization sufficiently disclosed those new types of data transfers? And are you making sure that those data transfers are compliant with, for example, the GDPR? If you have EU data and you had employees within the EU and you weren't too worried about transferring data outside the EU, but now some of those employees are working remotely, perhaps from countries other than the EU, perhaps from the United States. Have you addressed that situation sufficiently? It's a very tricky situation to address. So that is certainly something that a lot of organizations have had to deal with over the past 12 months. And then Ed and Hilary, I think, both touched on this briefly in terms of employees using personal devices or third-party services. So if your policies, your privacy policy on your website or your CCPA notice in California, if those have disclosed certain third-party services or contractors that your organization uses at a business level, that's all well and good. But now with remote employees, if they're using other services, perhaps they're using Dropbox just to transfer data from one of their own accounts with the business to a personal account, or vice versa, because they're working remotely and they type something on their home computer and they want to transfer it to their work computer. Though your data, your company data or your consumer's data may be transferred in that way using a third-party service, and you may want to make sure that your policies and your practices account for those types of third-party transfers on remote employees' computers that didn't even exist before or may not have existed within your organization. So you may not have given those a lot of thought before. So data privacy, there's a lot going on in this area. And I think another big area of discussion over the past 12 months has been employee privacy. And that particularly relates to what companies can do, both in terms of monitoring their employees, how they monitor their employees, and then what information employers can collect from employees with respect to health and wellness information, particularly regarding COVID. And so this is a bit more related to return to work than remote work, as employees do start to filter back into the office. Companies are certainly wanting to check their employees to make sure that they don't have COVID symptoms. They're protecting the other employees within the office. And so this has been a tricky area over the past 12 months. Thankfully, the EEOC has issued some substantial guidance in this regard. So if you are returning to work or you have questions in this regard, definitely consult those EEOC regulations and guidance documents. It relates to a number of different laws, including the ADA. So what accommodations do you have to give to employees who may be returning from remote work with symptoms or perhaps something that would qualify as a disability? The ADEA in terms of older employees or age discrimination with regard to return to work, Title VII, and a number of other state-specific laws and regulations, including Cal OSHA. So if you're in California, you probably already know this, but you've got a number of state-specific requirements relating to COVID, how you address COVID, how you create a safe working space for your employees as they return to work. And you may have obligations for making sure your employees are safe at their homes, which is an interesting wrinkle that I think a lot of companies have not necessarily thought about in terms of data privacy. And how do you manage that? How do you assess whether your employee's home working environment is a safe environment? And I've noted here that employers may be required to pay for necessary expenses. So there was a case just last year at the very, very beginning of the pandemic that reiterated at the Ninth Circuit level that in many states, employers are required to pay for necessary expenses. So if you're requiring your employees to work remotely, or even if you're just doing it as an option, you may be required to pay some of their expenses. If they need home internet in order to work remotely, you as the organization may be required to pay for their home internet or their cell service or their device, whatever device that is that they're using, whether it's a laptop or a tablet or even a phone. You may be required to pay for that. And then if you're required to pay for that, but it's really their personal device or it's their personal network, how do you assess the privacy implications of those networks? Can you monitor an employee's home network? Generally, employers can monitor employees during work hours or on company devices or networks, but that monitoring should be disclosed. And in some states, you might need to agree upon what it is that you're monitoring, how you're monitoring it, and when you're monitoring it. but you may not be able to monitor on personal devices or on home networks. And that creates some very difficult challenges. And the last bullet point that I've noted here, contact tracing, for example, has been a big issue over the past 12 months, as many of you know. And again, that may be permissible on company property. So if you're tracing or tracking individuals within an office environment to make sure that they're staying 6 feet away from each other, or if one employee comes down with COVID and you're trying to figure out what other employees may have been exposed to that employee with COVID, that's generally going to be okay on company property. But broader location tracking, for example, tracking an employee wherever their cell phone goes, even if it's midnight and they're walking with their cell phone to the refrigerator to grab a midnight snack, that probably is not or may not be permissible, particularly in a state like California, where there are specific location tracking prohibitions that you probably can't get around simply because you're an employer and you're trying to ensure that your employees are doing what you want them to be doing with regard to COVID. So this is a very tricky issue. A lot of this is still being tested within the courts. A lot of the cases have not yet been decided. So there's not a whole lot of clear solutions at this point. But again, the EEOC has issued guidance. So if you're following that guidance, if you're following the Cal OSHA guidance, you're probably going to be okay here. But again, a lot of these are open questions, and these are issues that a lot of companies are still struggling with, and again, may be struggling with for some time into the future as remote working continues. But now Ed's going to talk a little bit about some industry-specific obligations, particularly with regard to financial institutions. You are on mute. Ed.
Yeah,
there you go.
Sorry. Thanks, John. See, I told you I have to remember to unmute. One of the issues we found for some of our financial institution clients is that they have third parties, including law firms, that are holding their sensitive data. And with breaches like SolarWinds that Hilary was talking about, those clients need to reach out to their vendors that are holding their data to ensure that those firms have not been impacted by SolarWinds or some similar breach where their data may be exported away from those firms. And if you're a firm that holds that type of data, it may be important to take a look at the contracts you have with financial institutions to see what types of disclosures you need to make back to the financial institution. So some of the contracts, may be a little dated, and so they require only notice to the company if your system itself has been breached. Others may be much more up to date and may require that you give notice to the financial institution if you're aware that a vendor has had a breach, regardless of whether or not that breach impacted the firm. So one example that we saw was, as Hilary described, a company had SolarWinds. They did not update with the patch that included the malware. And as a result, they did not have the possibility for a breach within their systems because the SolarWinds hack was not on it. But the contract that they had may have required that they give notice to the financial institution that the vendor that they used actually had a problem. There are several sources that you can go to take a look at. One of the key ones is the GLBA, Gramm-Leach-Bliley Act safeguards. Those are followed by the OCC, the FDIC, the Federal Reserve Bank, and the Fed. And many states also opt into those safeguards. And what they require is that the financial institution take reasonable steps to ensure that the data that they have is secure. And some of the issues that have come up during the pandemic include the use of data on home computers. And the GLBA requires that data be encrypted when it's in motion and it's in rest. So as John pointed out, if an employee puts the data onto Dropbox, is it still encrypted? Maybe, maybe not, probably not. And so those are issues that the company needs to review its policies and procedures to make sure that it stays in line with the safeguards. One client that I spoke to is a large financial institution and significant resources, but they sent out laptops with virtual desktops on them to all of the employees that were working remotely from home. And that was their way to ensure that they didn't have the employee-owned devices over which they had no IT control, no ability to patch, and no ability to monitor what kinds of software was being downloaded by the individuals. The GLBA also requires that each endpoint device be secure. So whether it's a cell phone, a tablet, a computer, if it's receiving data that's subject to the GLBA, then it needs to be secured. So, for example, passwords on cell phones to open them, passwords to get into the company email, things like that. Some companies have also restricted remote access during certain timeframes. So when they know their employees are not supposed to be working, they shut off access so that people in the other side of the world are not accessing through phishing or hacking processes the company's information, and it gives them an opportunity to monitor a little closer what's happening. They will require, as I said, password protection for all devices, limit application downloads. I know our firm has virtual desktops on our laptops, and we have a limitation on what we can download. And even some systems that might help productivity have to be downloaded by the administrators. One of the other things that a lot of companies ran into is their VPN licenses were restricted in number, and they didn't have enough VPN access for all of their at-home use. And so they really had to expand the VPN licenses so they could have secure access to their data by their clients. And one other one that some firms use is they limit the print capabilities on external devices off the network so that you can't have an employee printing out restricted data and doing who knows what with it, throw it into the garbage, giving it away, who knows. John, if we can move to the next slide. The wire transfer fraud has been a big issue, and it was an even bigger issue during 2020. And what happens with the wire transfer fraud is through these phishing exercises that we've talked about, individuals will gain access to the email of one of the participants in a closing transaction. So in a business transaction, it may be an appraiser, it may be a law firm, it may be the client that's selling, the client that's buying. And once they're inside the email system, they'll monitor with snooping devices or software looking for any information that relates to a closing or a wire transfer. And once that pops up, they then step in and watch for the closing date. And they'll watch for an email for the closing that says, here's the bank to transfer the money to. And it's going to happen on Tuesday before close of business. So Tuesday morning, they'll pop in, either assuming the email address or spoofing the name on the email address by changing an L to a capital I in someone's name, for example. And then they'll step in and say, oh, we're having trouble with our bank account today. We're changing the delivery bank to the bad guy's bank in an account. And if people are not checking, the money will go out and it will transfer to the wrong bank. What typically happens is the recipient, the next business day or even 2 business days, comes back and says, hey, where's that wire transfer? I never received the closing proceeds. And by that time, the bad guys have 24 to 48 hours head start before anybody starts to search for the money. Training and mortgage closings, that's another big one. and I'll just touch on that briefly. What happens there is essentially the same process, and they'll get the realtor or someone that's involved in the chain for the closing to say, oh, I need you to send my commission to XYZ. And once they get in and they have that information, then they go in and they try to steal the actual closing proceeds for the sale of the home. And so the buyer is at the closing, they signed the title, they've got everything. But unfortunately, the seller doesn't get their closing proceeds. And then it's a battle as to who screwed up first or who screwed up the worst. Again, phishing is the primary access points. Any employee that deals with cash transfers should be trained in detecting the red flags that I discussed in the earlier slide. And, they should be on notice that any change in closing information or account numbers or anything like that is an immediate red flag that should be escalated. Any account change should be verified, and the verification should take place in an out-of-channel communication. And by what I mean by that is, don't send an email back to the individual that says, "Hey, I noticed you want to change the location or where the money's going to go," because obviously the thief is going to respond, "Yeah, that's correct." And if there's a phone number in the email, don't use that either, because in all likelihood, the thief has either ported that number or it's a bogus number to begin with. And again, they'll verify the transaction. So use a phone number that's on account ahead of time, or some other method to get a hold of the participant, the recipient, to make sure that that change is actually verified. We had one situation where an individual called back the cell phone number that was on record, and the person who answered the phone, instead of a Texas rancher, answered with an accent from someone that was overseas. And unfortunately, the employee took the word of the person with the incorrect accent, shall we say, and placed the transfer anyway. And that was a $400,000 mistake. If it happens, the first steps to take are to identify as much information as you can related to the transaction, and then report it to the FBI at their website, ic3.gov. If it happens within 48 hours, frequently they can grab the money and get it back. And they've had about an 82% success rate in 2020. And as you can see, the numbers are huge. To leave time for questions and answers, I'm going to turn it back to Hilary. Now you're on mute.
Thank you. We wanted to leave just a few minutes to give you the opportunity to put forth any questions based on today's materials, or questions you'd like us to consider as we put together our series of additional topics on this subject.
Yeah, we just had one question in chat. Yes, slide materials will be emailed, and I believe this presentation has also been recorded and will be available on our website as well. And we had another question in terms of virtual desktops and what that means and how those work. Ed, do you want to tackle that one?
Sure. So essentially the administrator for your entity loads the software onto the laptop, and all of the software on the laptop is controlled by the IT department. And the IT department has the ability remotely to access that computer and to make any administrative change that needs to take place on the computer. So with that, the administrators with password restricted access are able to add software, delete software, block a laptop from printing, block a laptop from downloading information to a thumb drive, and things like that. So it gives the IT department full access and control to the laptop to ensure that the security protocols are maintained.
Right. It's a bit like just being in the office or having your computer in the office. It's a direct connection between the IT department and the computer that the employee is using.
Yeah, it's like you're docked at your desk station, except you're docked at home.
Right. We have another question. Do we have additional advice as to how to disclose independent contractors and a sub-processor? So it is difficult to do. I think most companies that are attempting to do it are simply identifying categories of sub-processors. They're not identifying every possible sub-processor out there that an employee may be using. But I think really the policy in attempting to prohibit employees from using any third-party contractor that the company itself doesn't want to use or hasn't identified as a vendor are probably really the first step there. So try to prevent your employees from going out there and using third-party software or vendors to the extent that you possibly can. And then to the extent that you know that they're using some third-party software, even if it's Gmail or Dropbox or whatever it is for company business, then I would probably attempt to disclose that in a privacy policy or certainly in a CCPA notice in a way that communicates to consumers that, yeah, we have employees working remotely. Those employees may use certain third-party vendors, and we have X, Y, and Z policy that intends to keep those materials secure even when those employees are using those third-party vendors. But it is a very difficult question. It's obviously context specific, and it's going to depend on what those services are and how they're being used. And then sort of a follow-up question here that I just got about the virtual desktops. Are there any vulnerabilities for employees using virtual desktops? In other words, what are the risks there?
Well, for the employee, I think the risk, the purpose of the remote virtual desktop is to reduce risk. The company has limited the access to what the employee can do on it, and the risk to the employee of making a mistake by downloading malware or bad software or contracting with somebody that the company hasn't approved is much less. So I don't think, unless I'm misunderstanding the question, that there's really any additional risk to the employee.
Yeah, I would agree with that. I don't think there's a whole lot of additional risk. It's just one more way of trying to control what it is that your employees are doing on their devices. It's not going to be foolproof. They could still, if you have a company issued laptop and the employee also has a desktop at home, they could theoretically be working on their desktop at home doing something, even if they're not perhaps using the data directly from your company's systems. They could still be accessing in some way, shape, or form data on their desktop at home that isn't going to be subject to the virtual private network or the virtual desktop. But at the very least, it's one more step. It's a bit like multi-factor authentication. Again, that's not foolproof, but it's a good additional step to try to take in order to protect as much of this information as you can. And Hilary, I think you've got one more question to address here.
So the question that's been posed is, what liability would a company have in the case of damage to an employee's private property due to a network breach? And then it goes on to ask about working on company issued equipment. I think this is a very difficult area to tackle. Like I said, there's always the question of what it is that is being insured or is insurable by the company, and does it extend to employee property? And as John explained, there is risk when you've got employees using their own personal property, that there may be some obligation to provide compensation for using that property. And then I would say, yes, risk that if the employee's personal property is damaged because of a network problem on the employer side, that there could be responsibility for payment, although that's not been fleshed out at all. I think it's going to be very fact specific. And I think to the extent that the employee is being required to use personal equipment in order to accomplish his or her work-related tasks, that the liability issue becomes more and more great for the employer, which is why, as Ed said, those employers who have the resources, we have seen deploy company-owned equipment to their employees' remote working location in order to ensure that the company equipment being provided is the equipment being used, and hopefully to reduce some of the risk that's associated with that private equipment.
Yeah, I think that's exactly right. But it's an interesting question. I mean, certainly if you had a ransomware attack on a company network and that locked an individual out of their personal cell phone, I could certainly see how a company might be liable for that in some way, shape, or form, or at least the employee or probably class action employees may file suit. I think in most data breaches that we've seen, not just in the past 12 months, but over the past several years, when it is a wide scale breach, it typically does involve not only consumer data, but also employee data of a company who's been affected by a ransomware or other type of attack. And so when you get a class action, it typically does involve both consumers and employees. So certainly a company could be liable in that way for any harm that may be suffered as a result of something happening on company issued equipment. So it's a good question, really, something that I haven't seen specifically, but could definitely arise. I could see that. I think we're now a couple minutes over, so just thank you to everybody for joining. We really, really appreciate it. Appreciate the time. And certainly if you do have any questions, feel free to email us or look us up on the website. But we definitely appreciate the time.
Thank you, everyone.
Thank you, everyone.